Hofer.
Yes, Mr. Hoffner.
May it please your ladyship and your lordships, together with Miss Anna Glotz, I appear on behalf of the appellants, Messrs. Anthony and Alexander Alexiou. My learned friends, Mr. Khalil Parker and Miss Roberta Quant, appear on behalf of the respondent, Mr. Zachary James Galantis. This is my client's appeal from a judgment dated the 4th of May 2016 of the Court of Appeal of the Commonwealth of the Bahamas. A note of the oral judgment is in the record at Divide 30, page 857 to 858, and succinct reasons were delivered by the Court of Appeal some 7 months later on the 7th of December 2016, and a copy of the reasons are in the record at Divide 32, page 862. So it's Divide 30 and Divide 32. The fundamental issue raised by the appeal is an issue of statutory construction. It concerns the proper interpretation of Section 272 of the Bahamian Companies Act 1992 and its relationship to Section 280 of the same statute. And I'll return to address those individual provisions in a moment, if I may. Of course, the issue has wider implications. A similar provision is to be found in the legislation of many other jurisdictions around the world. In the United Kingdom, for example, a similar provision is to be found in sections 1000 and 1003 of the Companies Act 2006 as amended. And at least so far as our researchers have been able to establish, there is, surprisingly perhaps, no authority on the meaning of the word in any of the statutes, in any of the many jurisdictions around the world where the provision appears.
Which provision are you talking about?
I'm talking about the provision, section 272.
272.
Yes, which is the provision continuing liabilities. Subject, of course, to contrary direction, I was proposing to structure my submissions in the following way. First, I was proposing very shortly to deal with the proper approach to statutory construction. Second, I was proposing to identify just the essential facts very quickly. Third, I was proposing to consider and make submissions on section 280 of the 1992 Bahamian Companies Act, chapter 308, upon which these proceedings were founded. Section 280 is loosely referred to as the oppression remedy. Fourth, I was proposing to go then to the judgments in the light of submissions on section 280. Fifth, I was proposing to consider and make submissions on section 272 of the Act, that is the provision continuing liabilities, a provision which surfaced for the first time in the Court of Appeal and upon which the Court of Appeal's decision turned. Sixth, I will explain why in our respectful submission the decision of the Court of Appeal cannot stand and is wrong. And in conclusion, I was proposing in 6 essential propositions to summarize the appellant's case. First, in statutory construction, there is no issue that I can discern as to the correct approach to the interpretation of statutes. The Judicial Committee is more acquainted than most with the correct approach, and for this reason we have not added yet further authorities to the already overfull bundles, the Court's basic task is to give effect to Parliament's purpose. And in doing so, it must examine the words used by Parliament in their particular context. The relevant context of a statutory provision is both internal and external to the statute. The internal context requires the interpreter to consider how the provision in question relates to other provisions in the same statute and to construe the statute as a whole. The external context includes other relevant legislation and common law rules, as well as any policy documents, such as the equivalent of Law Commission reports of parliamentary committees or green and white papers, which form part of the background to the enactment of the statute. And when the strict conditions specified by the House of Lords in Pepper and Hart are satisfied, then reference may also be made to parliamentary reports, debates as reported in Hansard. That was all I was proposing to say on statutory construction. Before coming to the relevant provisions, I was proposing to remind your ladyship and your lordships of the essential facts which lie within a very narrow compass indeed. The essential facts are these. In July 1998, that is some 21 years ago, Mr. Galantis sold his shareholdings in a business known as BK Holdings Limited, together with its interest in a lease and its inventory of goods, to Alexiou Designs Limited. At the time of the acquisition, the appellants were the directors, or were directors of Alexiou Designs Limited. Alexiou Designs Limited paid 3/5 of the purchase price in cash, and the balance was payable in instalments secured by a promissory note. 300,000 in cash, 200,000 payable in instalments secured by a promissory note. Alexiou Designs Limited paid some instalments, but then fell into default. On the 17th of February 2005, some 5 years after the final instalment was paid, Mr. Galantis obtained judgment against Alexiou Designs Limited for the outstanding balance due and owing to him under the promissory note, together with interest and costs.
The 182 was made up of, well, how much was outstanding by then? It was about 164, I see, and the rest was interest.
Interest, yes. Then on the 25th of July 2008, some more than 3 years after judgment had been obtained, Alexiou Designs Limited was removed from the Bahamian Register of Companies by the registrar. Immediately prior to the removal of Alexiou Designs Limited from the register, the first appellant, Mr. Anthony Alexiou, was a director of Alexiou Designs Limited. The second appellant, Mr. Alexander Alexiou, had ceased to be a director of Alexiou Designs Limited some 8 years earlier, in 2000. Thereafter, on the 21st of April 2009, the proceedings giving rise to this appeal were commenced. Mr. Galantis sought relief pursuant to Section 280 of the 1992 Act against each of the appellants in his capacity as a former director of Alexiou Designs Limited. And those, in a nutshell, are the essential facts. I propose now, if I may, to turn to section...
Could I ask one question before
Yes,
you do that? The factual matrix also includes the behaviour of the directors at the time that Alicat's business was in effect transferred to another business. And what I understand the findings of fact by the trial judge to be that the assets were in effect stripped out of Alicat and taken up by the other entity owned by the appellants. You're not challenging that. And would I be right in also saying then that that would involve, by creating the insolvency of Alicat, that would involve a breach of fiduciary duty by the appellants to Alicat at that stage, based on West Mercia Sportswear, for example?
Correct, to the company.
To the company. But the purpose of the remedy to the company is, of course, to protect the creditors. That's why the common law extended the fiduciary duty of the directors in the context of insolvency to include creditors as well as members.
As I understand it, the fiduciary duty of directors is not extended to creditors in the context of this particular case. There was not in fact an insolvency. The company was never wound up formally. It came to a point in time where, because of inactivity, the company was struck from the register by the registrar.
But there was, in fact, an undisputed insolvency because its assets were transferred to another company when there was a principal debtor outstanding.
That is correct.
Principal creditor, yes. Thank you.
That is correct.
Thank you.
So there would be a liability on the part of the directors who were in breach of fiduciary duty to compensate the company.
To compensate the company, correct. Yes, yes, absolutely. That is entirely right. There are various different routes which may be taken in this sort of situation. I was proposing next, if I may, to go to the relevant provisions, or indeed section 280 of the Bahamian Companies Act 1992, and although the sections on their own can be found in a different place, I thought it most useful to go to Divide 38, that's Bundle 2, Divide 38, page 1433. And section 280 can be found at page 1558. Page 1443, as is apparent from the preamble, it is an act to consolidate and revise the law respecting the incorporation, management and control of companies. Section 280 appears page 1557 in part 9 of the statute, which is a part including civil remedies, civil penalties and offences, and it appears under the heading civil remedies. Amongst the remedies for which part 9 makes provision is the grant of permission to bring derivative proceedings on behalf of the company, section 279, and the restraining of oppressive conduct by the company or a director or officer of the company, Section 280. Under Section 280, the court may restrain oppressive action and make a rectifying order where, in general terms, 3 criteria are satisfied. First, there must be conduct, past or present, coming in within subsections A, B, 2A, 2B, and 2C. So first, conduct past or present, coming within subsections 2A, 2B, or 2C.
I'm sorry, are you treating 2A, B, and C as conditions to the grant of relief under 1? One is saying that you can apply for an order to restrain oppressive action.
Yes.
2 is saying if upon an application under subsection 1 certain conditions are satisfied, the court may make an order to rectify the matter complained of.
By means of restraint. If it were to be read otherwise, then subsection 2 would go wider in its effect than subsection 1, because subsection 1 is referring merely to oppressive action. In subsection 2, what is being considered is oppressive or unfairly oppressive conduct, or conduct that unfairly disregards the interests of a shareholder or debenture holder, creditor, director, or officer of the company. Then in those circumstances, the court may make an order to rectify the matter complained of. And then in 3, it begins in...
Sorry, I'm not quite sure I've understood the exchange. Is subsection 2 limited to restraining oppressive action under 1, or does it go beyond that?
It goes to rectifying the matter complained of.
So not necessarily by restraining it, it may be in some other way.
No, one of the items of relief at subsection 3A is to restrain the conduct complained of.
Yes, and in 3J there's an order compensating.
Correct.
So it's not necessary, it may be accepting the existence of a past act and compensating for it.
Yes, you can see in 2B, the 2 possibilities are contemplated: that the affairs of the company are being carried on in an oppressive manner, or that they have been carried on in an oppressive manner.
Correct.
And in ordinary language, you couldn't restrain something that had happened in the past, but you could rectify it.
Correct, yes.
Whereas if something is continuing at the present time, in ordinary language, you can restrain it.
That is correct. That is correct. In order to restrain oppressive action, there must be existing oppressive action. In order to rectify the oppressive, the cause of the oppression need not be ongoing. And that is why I say there are 3 elements to this. There is the first, which is the conduct at 2A, B, or C, which can be present or past. That conduct must have an effect. There's an element of causation. And third, the result complained of, it must produce a result that is oppressive or unfairly oppressive to, or unfairly disregards the interests of any shareholder or debenture holder, creditor, director, or officer of the company.
One way this might be read is that for there to be an application under Section 280, there must be oppressive action currently going on, because otherwise there's nothing to restrain. But that insofar as the oppressive action has already had consequences, because it's been going on for some time in the past, those consequences can be rectified by an order under subsection 2.
Yes.
That's one way of looking at it. And if that's the correct way of looking at it, that would mean that if the oppressive action has already been completed, then there cannot be a valid application under Section 280.
That is the way in which, in certain Canadian decisions, the similar provision has been construed. In my submission, the question as to whether the oppression was or was not ongoing is in fact a red herring in this case, which, but I'll come to that later if I may. I mean, we say there were clearly findings in that regard, but in truth, it's not crucial to the determination of the question which arises in this case.
So that's why, on that basis, you were willing to accept that restrain could just mean rectify. As I noted you earlier, you were saying restrain includes rectify.
Yes, the reason why I hesitate, my Lord, is because in none of the cases of which I'm aware has the court sought to draw a distinction between subsection 1 and subsection 2 in any way. One sees that this is a section on the left-hand side, restraining oppressive action. That's the context. And the way in which the cases proceed is to look at subsection 1 and subsection 2 together.
Thank you.
Can I just see if I can just get myself up to speed with regard to this by looking at the actual words of section 280 and putting to you a possible scenario?
Yes.
So that somebody, a complainant, applies to court under subsection 1.
Yes.
But establishes, to the satisfaction of the court, that the business or affairs of the company have been carried on, or in a manner which is oppressive, etc.
Yes.
Within 2B.
Yes.
That's enough, isn't it? You're within the section then.
Correct.
So that is a finished action, have been carried on.
Correct.
So you can't restrain something which is finished. So restrain must therefore have a wider meaning within this section. And we know that too, because when we turn over to the orders that can be made,
Yes.
only one of them is an order restraining.
Yes.
So restrain's a wider concept here, isn't it, than what you and I might think of as a day-to-day concept.
That is certainly, my lady, the way in which I have read it and the way in which the cases have read it. But in answer to the question from my Lord Reid, he points out quite rightly, in my view, that what one ought perhaps not to jump to that position, and one ought to look at 281 on its own to see whether that's a self-standing provision on its own, or whether one needs to look at 1 and 2 together, giving the words restrain a wider meaning. Now, in my view, it doesn't matter for the purposes of this appeal. the way in which I have approached it, and I think the cases have approached it, is in the way that your ladyship has identified, is that in fact one is using the language of restraining oppressive action quite loosely to apply to both restraint and rectification.
But I mean, the important point for our purposes is that you are prepared for us to approach this case on that basis.
Correct.
But you're nervous about us deciding a point which may be of more significance in a later case. Because the alternative is that the word restrain in subsection 1 governs the approach to the whole section, and that the other forms of remedy are incidental to that. But you're not advocating that in this appeal.
That is correct. And for the purposes of this appeal, if there is a distinction to be drawn, on any view, this is a 282 subsection 2 case and not a 280 subsection 1 case.
But where I was going was then a past act
Yes.
is sufficient to give rise to a liability under section 280.
A past act must cause oppressive conduct. And so one needs to separate in one's mind the difference between the act and the effect which the act has. And the cases, or at least some of the cases, suggest that whilst the act may be passed, the oppression must be felt and must continue.
Comes from that is oppressive, doesn't
Correct.
it, in that rider?
Correct. That is absolutely right, my lady.
I suppose an example of that would be a share dilution.
That is correct, yes. Yes, or amongst the cases, the famous BCE Canadian case, which involved restructuring of the telecommunications company, which had an impact upon, an unforeseen impact upon debenture holders. So I've identified what we say are the three parts to section 280 subsection 2. The provision is clearly and obviously discretionary, and that's common ground. The court may make an order, and under 3, if it decides that it should make an order, it will make an order that it thinks fit in the circumstances. Subsection 3 then spells out some of the relief that the court may grant, and we see, as we did a moment ago, at A, an order restraining the conduct complained of, at B, appointing a receiver or a receiver manager, at F, an order directing a company or person to purchase shares or debentures of a holder thereof, perhaps the order most encountered in practice, following the guidance provided by the House of Lords in the O'Neill and Phillips decision, 1999, 1 Weekly Law Reports 1092. Then at J, the one relevant in the present context, an order compensating an aggrieved person. At L, an order liquidating and dissolving the company, which is a separate order which the court may consider to be fit, and at M, an order directing the registrar to make a preliminary investigation into the company. Some of the examples enumerated in subsection 3 contemplate remedies directed not only at the company, but also at other parties. However, as the final words of section 280 subsection 2 specify any order exists solely to rectify the matter complained of, and this reflects the corrective purpose of the remedy. It seeks to correct injustice or unfairness, as is apparent from the authorities to which we refer in the appellant's case, a proposition which is uncontentious. Perhaps the two leading cases in Canada are decisions of the Supreme Court of Canada in Wilson and Alexiou at Authorities Bundle Divide 29 and BCE in 1976, the bencher holders at Authorities Bundle 15. But I wasn't proposing to take your lordships to those at this stage.
Those are you saying that A to N are all examples of orders rectifying the matter complained of?
All of the orders at A to N, we say, are types of order that may be made to rectify the matter complained of. If it were not so, there would be no statutory guidance as to the circumstances in which the court could make any of the orders at subsection 3. And so subsection 3 must be read as following directly on from subsection 2.
I see. So the seeming width of the opening words of subsection 3, that the court may make any interim or final order it thinks fit, you would read as implicitly saying any interim or final order it thinks fit in order to rectify the matter complained of.
It must serve that purpose.
Yeah, I mean, some of the orders are really just steps on the way, aren't they? I mean, for example, well, N, an order requiring the trial of any issue, or L, an order liquidating the company. I mean, for example, in the present case, one way of rectifying the issue might be to appoint a liquidator who could in turn then enforce the company's rights against the directors.
Yes.
But the appointment of a liquidator wouldn't in itself rectify the matter complained of.
No, but it may be one of the steps that is required in order to rectify the matter complained of. And it must serve that ultimate purpose. My lords, my lady, in this bundle, on that point, may I refer you to Divide 29, page 1322, which is the recent Supreme Court of Canada decision in Wilson and Alexiou, where the substantially similar provision in the Canadian legislation is considered by the Supreme Court, and The analysis of the provision begins at page 1333, paragraph 22 of the judgment, and the Canadian Business Companies Act provision, section 241, is there set out. And at paragraph 23, the nature of the remedy is explained. To 24, the two requirements for an oppressive act, for an oppression claim are set out. And the question in that case was whether the trial judge had appropriately exercised the remedial powers provided in section 2413 by holding Mr. Wilson personally liable for the oppression. And at paragraph 27, the Canadian Supreme Court said this: an order made under section 241(3) exists solely to rectify the matters complained of as provided by section 241(2). The purpose of the oppression remedy is therefore corrective, quote, in seeking to redress inequities between private parties, the oppression remedy seeks to apply a measure of corrective justice. In other words, an order made under section 241(3) should go no further than necessary to correct the injustice or unfairness between the parties.
There's no reference to restraint in section 2411, is there?
No, there is that distinction between, again, our researchers suggest that it's only the Bahamian statute that has added the words "in order to restrain oppressive action."
We don't know where that came from.
We don't, I'm afraid, no. I was about to turn to the external context, and in that context, there's very little that we can say. The oppression remedy was first introduced into Bahamian law in 1992 in this Act. It appears to have been modelled on section 234 of the Canadian Business Corporations Act 1974, now section 241, which we've just looked at, of the Canadian Business Corporations Act 1985, which is in the Authorities Bundle, tab 451659. There is no established line of Bahamian authority discussing the scope and purpose of section 280. The parties, it appears, agree that reference to Canadian law is therefore instructive, although caution must be exercised. As has been pointed out, the statutes are not completely identical.
Could you help us to what the continuing oppression was in the Wilson case, please?
Yes, just bear with me one moment. The way in which, if I just find the paragraph though, the way in which, this is my understanding of it, the way in which the Class C shares had been set up, that's paragraph 5, was as an incentive to those involved in finding financing. The C shares were convertible into common shares if the corporation met a financial target, and Mr. Wilson was one of those of the C shareholders and beneficially owned or controlled 100,000 C shares through another company, the company had cash flow issues, and it began to consider a merger with another company. This is paragraph 6, Mytec, and whilst negotiating the merger, the respondent was also separately negotiating with Mytec the sale of his own shares in the corporation in order to alleviate personal financial difficulties, and without notifying the board, the respondent agreed to sell some of his common shares to Mytec, the company that was going to take over, or it was proposed should take over the company. And when the corporation's board learned the respondent's personal share purchase agreement, he was censured for concealing the deal and failing to disclose the potential conflict of interest. This led to his resignation from the company.
I'm just wondering what the continuing oppression was, because what we read in the head note is that the value of his shares was substantially reduced, so he brought a claim for oppression, and what he was seeking was compensation.
Yes.
So what's the continuing oppression there?
The fact that what had happened was having a continuing effect on the value of his shares.
Yes, it looks as though, I'm just looking on page 1323 in the head note, about halfway down the left-hand column, in the first full paragraph, second last sentence, we're told that the proportion of his common shares was substantially reduced. So
Yes.
it looks as if there's a share dilution issue here.
But they
that is
weren't
entirely right.
doing anything oppressive that could be restrained. It had been done, and it had had its result.
Correct. If one looks at 280 and the three criteria, there was a past act which had a causative effect, and it was having an ongoing oppressive effect in that the value of his shares remained diluted. It had been and remained diluted.
Is that different from remaining unpaid as a creditor?
No, it's not. I mean, that's in a sense why I say this. The question as to whether the oppression is or is not ongoing is a red herring, which unfortunately clouds rather than clarifies the issue in this case, as I see it. And to the extent that we're responsible for introducing that red herring, I apologise.
It does feature in your case.
It does, yes. But yes. Well, I'll come to deal with that later.
Yes.
It certainly does. I accept that entirely. So I've dealt with the external context, just some conclusions in relation to Section 280, drawing the threads together. Section 280 creates an equitable remedy. The court may make an order to rectify the matter complained of, an equitable remedy that seeks to ensure fairness. It's been said by the Canadian equivalent that its remedial purpose lies in applying general standards of commercial fairness, given the sometimes clumsy tools of the common law, which fail to promote such standards. fashioning a fit remedy is a fact-dependent exercise. Thus, conduct may be oppressive in one context, but not in another, and that is taken from the decision of the Supreme Court of Canada in BCE in 1976, debenture holders, divide 15 at paragraph 59. Further, conduct may be oppressive at one point in time, but then cease to be oppressive at a later point in time, because, for example, the circumstances which make the conduct oppressive no longer exist. And for this reason, as was pointed out in both of the leading Supreme Court decisions, it's impossible exhaustively to catalogue the situations in which a remedy will or will not be granted. The exercise performed by the court is therefore to determine in any given case whether it is fit to give relief, and if so, what form that relief should take. The court is involved in fashioning a fit remedy. And again, that's paragraph 62 of the BCE case, the Supreme Court of Canada case. The exercise performed by the court is not to ascertain and declare whether a liability does or does not exist, still less whether a liability did or did not exist, although of course it may, in any given case, have to determine whether a fit remedy entails the imposition of a personal liability upon inter alia directors.
So say for, just think of an example, say for example, there had been directors directing the transfer of the company, stripping the company of its assets and transferring them to another company under their control. One possibility would be to appoint a liquidator who could either go against the recipient of the property if the conditions for getting it back as a fraudulent preference or something of that kind were satisfied, or alternatively, or some sort of gratuitous alienation, or alternatively, the liquidator could go against the directors for a breach of their fiduciary duty, or you could order the directors to pay compensation. Yeah. And the compensation might be payable to the company, or it might be paid to creditors who had missed out, I suppose.
All of those steps are steps which are can be taken in those circumstances.
You referred in your summary to Canadian jurisprudence saying that the remedial purpose lies in applying commercial fairness.
Yes.
Because of the clumsy tools of the common law. Yes. Do you have a reference to that?
I do, yes. That is the case at Anderson Wilson, which is 21, tab 21. Sorry? 29, sorry, yes, tab 29. It's the one I referred to a moment ago, and it's paragraph 39 in the decision of the...
Thank you very much.
While this proposition may remain true at common law, section 241's remedial purpose lies in applying general standards of commercial fairness, given that the sometimes, quote, clumsy tools, end quote, of the common law failed to promote such standards, and the court was there drawing on the learning of, I think it's Professor Kernan, at page 2 of an article which they were referred to.
Thank you very much.
Yes, it's Marcus Kernan, Oppressive and Related Remedies, 2004, which is an authority that's referred to in the judgment. It was an application under this provision that Mr. Galantis launched on the 21st of April 2009. When the application was made, as I said a moment ago, there was no mention of Section 272 of the Act. I was proposing next to go again quickly to the judgments, which, and because Section 272 was not mentioned at first instance, I was going to invite you very quickly to look at the judgment at first instance, which is in the record at Divide 20 and begins at page 620. As is apparent from her summary, towards the end of paragraph 7, page 623, the learned judge concluded that the first appellant, Mr. Anthony Alexiou, had acted in a manner that was oppressive or unfairly oppressive to, and or that unfairly disregarded the respondent's interests as a creditor of Alicat Designs Limited, and that the second appellant, Mr. Alexander Alexiou, had at the very least unfairly disregarded the respondent's interests as a creditor of Alicat Designs Limited. At paragraphs 146, page 654, and 148, page 655, the learned judge described these as an arguable case and as a potential claim. Despite the conclusions, the learned judge refused to grant the declarations sought, concluding at paragraph 160, page 658, at the end of subsection 1, that to do so would serve little purpose in light of my other determinations. And the other determinations to which she referred were those set out variously in the judgment. Those were to include paragraph 147, page 655, that Alicat Designs Limited was no longer in existence at the time that the application was brought. Paragraph 146 at the top of the page, that this was because Alicat Designs Limited had been struck off the register, that as a result, paragraph 146, the final sentence, the oppression was not susceptible to being corrected, and paragraph 150, the appellants could no longer be restrained under section 280. Similar language was used earlier in the judgment at paragraph 105, page 645 of the record. The final sentence, the court is not now in a position to make an order to rectify the matter complained of. And at paragraph 108, in the middle of the paragraph, lower down the page, the company no longer exists for any order with teeth to latch onto. And as a consequence, at paragraph 156, beginning at page 657 of the record, over to 658, she concluded that the oppression is not ongoing. And in our submission, those are a summary of the other determinations to which the learned judge was referring in paragraph 160, subparagraph 1. Well, the decision was successfully appealed, and the Court of Appeal's reasons are at divide 32. These, as I mentioned, followed some 7 months after the decision was made orally in the matter. This is page 862 of the record. And if one turns to paragraph 18, page 871, one sees that 3 of the declarations sought by Mr. Galantis were granted, and an order for compensation in the sum of the judgment debt together with interest and costs was made pursuant to section 280, subsection 3J of the Act. And the essential reasoning of the Court of Appeal is set out in paragraphs 14, 15, 16, and 17, which, if I may, I was going to invite your Lordship and your Ladyship to read. In our submission, it is evident from these paragraphs that the Court of Appeal's decision rests on the proposition that the appellants were under a liability for oppressive behaviour at the time Alicat Designs Limited was removed from the register, which liability was continued thereafter by section 272. And it's this, we submit that this proposition is unsustainable. Before I explain why, let me deal with Part 8 of the Act and Section 272 in particular. That is, in Authorities Bundle, divide 38 and Section 272 may be found at page 1555, 1555. And Part 8 begins at page 1553. It's a section headed Administrative Matters, and it includes at paragraph 271 the registrar's power to remove companies from. It also includes provisions enabling the registrar to restore companies to the register, and it specifies the effect of the registrar so doing. And at section 271, as regards the effect of removing a company from the register, 6 circumstances are set out in which a company may be removed from the register. And one of those is F, where a company has ceased to carry on business. A is where they failed to submit returns, which was obviously the case as well. And then the effect of removing a company from the register is addressed in sections 272 and 273. Dealing with those in reverse order, section 273 provides for the automatic dissolution of the company, and section 272 provides that the liability of the company and of every director continues and may be enforced as if the company had not been removed. The dissolution becomes effective when the company is removed from the register pursuant to section 271, and this removal marks the termination of the company's legal personality and hence its existence. Insofar as the 1992 Act provides for the dissolution of the company, but the continuing liability of its directors, it reflects the law as it stood in the Bahamas since 1926. Provision to this effect can be traced back, as we set out in our case, to the Removal of Defunct Companies Act 1926. That's Divide 39, page 1588. And the equivalent provision is in section 6 at 1589. But unlike its predecessors, the 1992 Act also provides for the continuing liability of the company itself.
And in that respect, it differs from other similar provisions, including the UK one.
With one exception, yes, which I'll come to immediately. I mean, it's in fact, again, a sideshow for present purposes because we're concerned with directors, but an examination of Hansard sheds no light upon the parliamentary intent behind the amendment, and we've been unable to identify any judicial authority in which it's discussed. This may be thought to be unsatisfactory, since there may be thought to be no obvious means of reconciling the dissolution of the company with the continuation of its liabilities thereafter. Ordinarily, dissolution would mark the termination of personality and hence existence. All liabilities would cease to be recoverable, and it would no longer be possible for an effective action against the company to be commenced. The solution may be that the liabilities of the company may thereafter be enforced against property vesting in the treasurer under section 273, or that the resurrection of the company under section 271(4) may be necessary for that purpose. The one exception to which I referred in answer to my Lord Hodges' observation is Saskatchewan Business Corporations Act 1978. It contains a provision, section 291, in materially identical terms, but under Saskatchewan law, there's a material difference. A company created under Saskatchewan law is specifically not dissolved when it is struck off the register. The Act creates a distinction between dissolution and a failure to maintain registration. And the Saskatchewan provision, as I say, is in the authorities Divide 46 and 47. It does seem, however, that as originally enacted, the 1992 Bahamian Companies Act did not expressly provide for the dissolution of the company upon its removal from the register. And the reason we say that is because Section 273 was only inserted pursuant to an Amendment Act in 1993, a year later. That is at Divide 43, page 1615 of the Authorities Bundle. And it was done, apparently, to, and I quote, make clearer the position that a company which is removed from the Register of Companies is considered to be dissolved. And that was applied retroactively from the 1st of August 1992, the date upon which the Act became effective. And one really can't tell, but it's conceivable that Parliament perhaps overlooked the amendment it had made to Section 272 a year earlier, but I'm afraid I can't provide any explanation for it. In any event, however, a provision continuing the liability of the directors, which is what's important for present purposes, has been part of Bahamian law since 1926, and it follows that a detailed analysis of Parliament's presumed intention in subsequently extending that provision to the company itself is unlikely materially to assist in the construction of the statute.
And I see from Section 274 that companies can still be restored to the register.
Yes.
Yeah. Well, that looks as if it's an amendment made in 1998.
That is possible also under 271 subsection 4.
Oh, yes.
Which was in the original statute.
Yep.
What then is the purpose of Section 272? A question that must be asked in construing it. The circumstances in which a company may be struck off the register, Section 271, subsection 1, lie within the director's control. The purpose of Section 272 is accordingly to ensure that the directors of a company cannot escape their liabilities by causing their company to be struck off. This proposition is supported by judicial and textbook discussion of similarly worded provisions in other jurisdictions, and we give examples at paragraph 43 of the appellant's case. Section 272 contemplates that actions to enforce such liabilities may be commenced after dissolution of a company. No time limit upon the commencement of any such enforcement action is imposed in this part of the Act, with the result that ordinary limitation rules would typically apply. And for clarification, it accordingly forms no part of the appellant's case that Section 272 only applies when a judgment has been entered or an order made against the company or its directors prior to the company's removal from the register. Such a construction would deprive Section 272 of any purpose. But the liabilities envisaged under Section 272 plainly extend to both criminal and civil liabilities and include liabilities owed to the company and to other third parties. And we say that a liability in this context is a condition of being subject to an obligation as a matter of law. Liabilities are conditions which exist as a matter of legal right. Upon a proper construction of Section 272...
Sorry, condition of being subject to an obligation.
A condition of being subject to an obligation as a matter of law.
As a matter of, and
Common-
is that something you get from other authority, or is that your formulation?
No, unfortunately, there's no guidance on this.
So that's your
That's our submission. And I'll come to develop
as a
that.
matter of law, as opposed to a discretionary remedy, is that what you're talking about?
Correct. We're talking about an obligation which arises under the common law or which arises under statute as a matter of right, as a matter of legal right. And I need to expand on that.
You said it extends to obligations under the criminal law,
Yes.
whether or not you've been charged with an offence, whether or not you've committed an offence. What stage in the criminal law does the liability clock in?
The relevant liability here would be a fine, and that would, in the context of a criminal matter, arise at the time of sentence.
So there's the fact that you've committed a crime and are liable to be charged for it is not enough.
It's not enough because the process of sentencing is a discretionary process and involves imposing the liability which is fit for the particular crime.
So it's when the liability sort of crystallises in the sense in a specific amount of money for which you are liable in law.
In your definition of liability, would you include the liability of the appellants to the company for breach of fiduciary duty in their failure to have regard to the interests of the creditors when bringing about the company's insolvency?
If a liability were established on the part of the appellants to the company, then that would be a liability which would continue.
But the findings of fact, I think we've already agreed, support such a liability.
I need to come to this and deal with it slowly, if I may, because...
Well, there's a separate point which you'll be arguing in a minute, which is that that doesn't apply to the Section 280 remedy, which is discretionary, etc. But I'm wanting to test your point. You say that the liability is the condition of being subject to an obligation as a matter of law.
Yes.
If you accept that the directors were, in stripping out the assets of ADL in breach of their fiduciary duty, they had a liability to the company at the point of dissolution.
So if there's a common law, obligation or a statutory obligation which has been breached, it's not the declaration by the court of that which is crucial, but it's the existence of the legal obligation or the legal liability.
Well, the obligation to compensate for the consequences of the breach of fiduciary duty would be an equitable obligation, wouldn't it? I mean, certainly a trustee's obligation to compensate for the breach of his fiduciary duty would lie in equity. I suspect the same would be true of a company directors.
I need to think further about that, but my understanding is that it is a common law legal liability and not an equitable liability.
But in either event, would that make any difference, whether it was legal or equitable, to your proposition?
Well, the answer is that it may make a difference, yes, because in the context of an equitable remedy, there are a number of different options open to the court exercising the equitable jurisdiction, and it's for them to make an order which they think is fit in the circumstances. And indeed, as Burkitt and James, Lord Wilberforce, from recollection, said that in the context of the exercise of a discretion, you may have two judges in the same situation coming to different decisions because they weigh the factors, both doing so in a principled way, but because they weigh the factors in a different way. And therein, we say, lies a crucial distinction. That is,
in that, you say, clearly arises under the section we're concerned with. I wouldn't want to get too far into the extent to which an equitable liability in other circumstances can be regarded as clear-cut.
Yes, in the consequences of section 272, when you're talking about the preservation of the liability of a director, perhaps differently with a member, but it would be perhaps a strange provision to exclude from that liability arising from equitable obligation.
That may be the case.
This maybe another way of looking at the point that's at the heart of your argument, which is essentially that the presence of a discretion prevents from being a liability until the discretion has been exercised.
Correct. That's at the heart of it.
Yeah.
That's to split the remedy from the wrong and say that the liability only arises once you've got the remedy, whereas the wrong arises earlier.
That is right, but we're not dealing here, that's the very point, we're not here dealing with a legal wrong. We're dealing with a set of circumstances which may be classified as wrong. When those circumstances exist, the court is empowered to provide relief. And where you have a tort that's been committed, you have a legal wrong. Here you've got a set of circumstances which may or may not entitle you to relief, depending upon the way in which the court exercises its discretion.
Why isn't the conduct that brings you within subsection 2 the same as the tort that gives rise to the remedy? What you get will depend on the circumstances.
Because the one is a legal wrong as a matter of common law or statute. The other is merely a set of circumstances which may or may not give rise to relief. So there is a crucial distinction between them. Section 272 does not itself create any liability. It merely continues liabilities existing on the date of the company's removal from the register. This, we submit, is manifest from Parliament's use of the phrase shall continue in section 272. A liability self-evidently cannot continue unless it has already an existence. And statements to that effect may also be found in the case law of other jurisdictions in which similar statutory provisions exist. We give examples of paragraph 48 of the appellant's case. This limitation on the meaning of the word liability, we submit, is not only mandated by the language used, but it's also logical. Once a company is dissolved, there is no company in existence, and so also no directors upon which a liability can be imposed. It necessarily follows that any liability continued by section 272 must be one already incurred by the directors in their capacity as directors prior to the company's dissolution. Put another way, Parliament cannot conceivably have intended section 272 to be used as a means of imposing a personal liability on individuals at a time when they are no longer directors and where no such liability previously existed. And so the fundamental question, as we've seen, is what is a liability within section 272. As we've said already, patently a judgment or order of the court is not required. Section 272 contemplates that proceedings to enforce a liability may be commenced after the company has been struck off. Hence, a liability for the purposes of section 272 may exist at the time of dissolution, even if that liability has still to be declared by a court in proceedings. And I've given examples already. A statutory liability is imposed upon the directors of a company. The directors dispute that statutory liability following dissolution. The court gives judgment. In that case, the liability exists as a matter of right prior to the dissolution. It's prescribed by statute. The judgment of the court merely operates to declare the existing liability. And it's important to note that the 1992 Act itself contains numerous examples of defined liabilities existing as a matter of right. So, for example, section 27, subsection 2, page 1458 to 9, this subsection renders directors personally liable to the holder of a bill of exchange, promissory note, cheque or order for money or goods in the circumstances set out. Similarly, section 101 and 102 on page 1491 and 1492 of the record of the authorities bundle renders directors liable to a civil penalty in the circumstances set out. Renders directors jointly and severally liable to the company in the circumstances set out.
Which section is that?
Sorry, that's section 101 and section 102.
Yep.
And then also in part 9, section 286, page 1561, under the subheading Civil Penalties, section 286 renders directors liable to a civil penalty in the circumstances therein set out. And over the page, under the heading Offences, at 288 to 298, renders directors liable to criminal penalty and or upon conviction to a fine in the circumstances therein set out. And we say a similar analysis applies where a director has a liability to third parties at common law in connection with the company. For example, a director will be liable if he has contracted to make himself personally liable to a third party, or if he's committed a tort in relation to the company's affairs whilst acting as a director of that company. In those cases, the existence of the liability is prescribed by common law. The liability exists as a matter of right prior to dissolution, and in the event of the dispute, the judgment of the court merely operates to declare it. The position is otherwise, however, where at the time of dissolution, any liability is dependent upon an exercise of the court's discretion. Until the discretion is exercised, there is no liability in existence at all. There is no immediate liability to pay, and absent an exercise of the court's discretion, it cannot be said for certain whether such a liability will arise at all.
But why, what's the legislative purpose of limiting the word in that way? I mean, if the object of section 272 is to ensure that dissolution of the company doesn't sort of prejudice anyone's rights against the directors who may have been responsible for the dissolution. Surely liabilities should include potential liabilities, otherwise you're leaving out a class of people who deserve protection, aren't you?
Two answers to that. There may be other routes more appropriate routes to protection, which are envisaged by the statute. Number one, such as applying for the company to be
restored to the register.
But why should that apply? If you owe a common law debt to the company, why would 272 preserve that liability, but not another form of liability? In each case, restoring the company to the register would be a route to recovery. What's the difference?
The difference is the one is a liability, we say, and the other one is not a liability, on the plain and ordinary meaning of the words. But in answer to my Lord Carnwath's question, there is an important point here in relation to certainty and
certainty of whom? For the director? Or for
yes.
Just say a director was in possession of some of the company's property. At common law, he would be liable to pay the company the property's value. In equity, he might be ordered to return the property. So under Section 272, is no liability either to pay value or to return the property, because you don't know which the court would have done if it had gone to court, or is there perhaps a liability to pay the value, because that would be the common law remedy, but not to return it because that's the equitable remedy? That's a very simple example. I was wondering how, on your analysis of Section 272, that example would be treated.
The way in which it would be treated is that any liability which arises as a matter of law, as a legal obligation, would survive and continue, but anything short of that would not, and again for good reasons, as I said, certainty, but also because if it were otherwise, how is a court to decide in relation to 280, subsection 3, which is the fit and proper remedy?
Yes, I see.
The court is going to have its hands tied at that stage, and whereas before the company's dissolution, it might have decided to go down a particular route, it feels after the company's dissolution the only way in which it can do justice now is to order compensation, and that would be quite wrong.
Yes.
And that is why liabilities here means liabilities properly so called. It's those which are in existence and not those which are prospective.
Is there any discussion in the Canadian cases or textbooks of the relationship between this remedy and the alternative remedy of restoring to the register, which you mentioned?
In many of the cases, the applicants pursue both routes. The court does what it considers to be best in all of the circumstances. None of the cases, however, are cases in which the company had been dissolved. That's the difficulty. That's why there is no authority. There is no case which has had to consider this post-dissolution. Yes, companies have ceased operating. In some cases, they've ceased their business, but none of them have actually been dissolved as a matter of law. And so none of the cases...
They've been But have they been removed from the register?
No, none of the cases have been removed from the register.
No, I see, that's what I was asking. Was there any discussion of the relationship between?
Sorry, I misunderstood.
No, and the textbooks don't deal with that.
Textbooks, we'll come to in a moment. The textbooks do speak about liability in the way in which I have defined it, because they talk about statutory or common law liability. And I was going to come to that.
Can we see that, please? Sorry, I was wondering, can you give us the reference to the textbooks again? I think it's in your case.
Yes, just bear with me one moment. It's, the references are Gower, Principles of Modern Company Law, tab 33, page 1399, specifically contemplates liabilities in respect of common law or statutory duties. Pennington's company law, divide 36, page 1431, contemplates at footnote 20 misfeasance proceedings and an action for breach of duty. And obviously misfeasance proceedings are those, or their words used carefully by reference to the statute, the company statute, and there's the Madras High Court decision of Chitra Desai at Authorities Bundle 17, page 1138. And those are referred to at paragraph 43 of the appellant's case.
So Pennington refers to breach of duty, you say,
Yes.
in footnote 20.
Oh, I'm sorry, I referred you to 43, it's 56.5 is where these authorities are. Yes, Pennington does refer to an action for breach of duty, yes.
By which reference is that? As 1431?
Yes.
That's the reference at 1431, yes.
Footnote 20, yes.
That is, we submit a situation where there has been a breach of a legal duty.
And the reference to the Chitra case was?
Divide 17, page 1138,
Okay.
at paragraph 146 in the judgment.
This provision has been introduced by statute to prevent applications made voluntarily by directors to remove the name of the company with a view to screen themselves from any possible action for acts of mismanagement or misappropriation.
All the stuff.
Yes, thank you.
as I was saying, it's until the discretion is exercised, our case is no liability in existence at all. There's no immediate liability to pay, and absent the exercise of the court's discretion, it cannot be said for certain whether such a liability will arise at all. This, we say, is the proper analysis of Section 280, in contrast to the examples I've given. Section 280 does not itself prescribe or define the liabilities of the directors in the event of oppression, nor does it impose liability on the directors in the event of oppression. On the contrary, it confers upon the court an equitable jurisdiction to make an order restraining oppressive action if, in the exercise of its discretion, it considers such an order to be fit in all of the circumstances. Although, if it finds oppression to exist, the court may elect to impose liability by ordering a director to compensate an aggrieved person, it is in no way obliged to do so, and there are a number of different orders that the court may elect to make instead, and which do not entail the imposition of any such liability. Indeed, it may elect to make no order at all. Further, the court may conclude that the conduct relied upon ceased to have oppressive effect, and that Section 280 accordingly is no longer satisfied. So we say, giving the words their ordinary and natural meaning, we say it's plain that Section 272 does not apply where at the time of dissolution the imposition of a liability has not occurred and may never occur, being wholly dependent upon some future exercise of the court's discretion. Or to put it another way, Section 272 only applies where prior to the dissolution of a company the director's liability has either been imposed by a court in the exercise of its judicial discretion or defined by law. Just returning to the deterrent effect, the purpose of Section 272 is to ensure that the directors of a company cannot escape their liabilities by causing their company to be struck off the register. In other words, the section is intended to act as a deterrent, and in order for it effectively to do so, it is imperative that the liabilities continued thereby definitively exist, which is the point on certainty. The directors should be left in no doubt as to the existence of their liabilities, such that an informed decision whether to remove the company from the register, actively or passively, can be taken. And the case of the facts of the case BCE, the Canadian telecommunications case, point to that, because the directors in that case, it never crossed their minds that what they were going to do might be oppressive to some class of debenture holders. And in those circumstances, certainty in our submission dictates that the directors, any liability which they will obviously know about is continuing, but that which may or may not be imposed by a court at its discretion does not. Where at the time of dissolution the court has not exercised its discretion by ordering payment of compensation, the directors have no knowledge whether an action will be brought, and one needs to put this in the context of cases that might arise around the world, no knowledge of the range of factors capable of exercising the court's discretion if an action is brought, no knowledge whether an order will be made, and if an order is made, no knowledge whether that order will be one that imposes a personal liability to make payment as a means of restraining oppressive action. And in the interests of certainty, a line must be drawn, and we say Parliament has drawn that so as to exclude from section 272 liabilities which at the time of dissolution do not presently exist and of which the directors are accordingly unaware, but which may come into existence upon a subsequent exercise of the court's discretion. That we submit is the ordinary and natural meaning of the word liability. Had Parliament intended section 272 to be used so as to render a director liable where prior to the dissolution that liability was not defined by law or had not been imposed by a court in the exercise of its judicial discretion, it could and would have done so. And we say that there are examples in the statute, 1992 statute, where such comprehensive language is used. Section 155 3A, divide 38, page 1517, speaks of liability or obligation due or to become due. And at 255 on page 1547, uses the language of claims against the company, present or future, certain or contingent, ascertained or sounding only in damages. And 256 over the page refers expressly to future and contingent liabilities. And that Parliament did not use such language is indicative of its intention to confine liabilities to those existing as a matter of right at the time of dissolution. And as I say, I've referred you to the textbooks and the Madras High Court decision. The further point is that, of course, in 1926, when this provision 272 or its equivalent became law for the first time, there was no oppression remedy in existence in Bahamian law. And Parliament's intention when she enacted section 272 was not directed to the potential imposition of liability as a form of relief from oppression. Such a relief is of a different kind and dimension from the liabilities from which section 272 was originally passed, and in our submission falls outside its scope and purpose.
See the force of that in relation to section 280. Could I take you back, please, to the breach of fiduciary duty? Because in Bahamian company law, it doesn't just rest on equity. There's a statutory provision imposing that duty.
Yes.
Section 81 on
yes.
1485.
Yes.
So what we have here is an admitted breach of statutory duty, a breach of duty under the Companies Act, a failure to act in good faith with a view to the best interests of the company, which pre-existed the dissolution of the company. Yes. Okay.
Which section was that?
81.
81, thank you.
It's a statutory obligation to exercise due care.
No, it goes beyond that. Honestly and in good faith, B, exercise the care, diligence and skill that a reasonably prudent person would exercise in comparable circumstances. It's A I'm referring to. It's a statutory codification of what otherwise would have been an obligation in equity.
That is absolutely right. It is a statutory obligation.
Now, Mr. Hofmeier, are you reaching the end of your submissions now?
I am. I'm sorry that it's taken longer than I had.
No, we've had quite a lot of questions for you. I'm conscious of that.
Let me just then turn very quickly to deal with why in our submission the Court of Appeal's decision cannot stand. We say it's necessarily implicit in the Court of Appeal's judgment is a finding that the appellants were under a liability at the time of dissolution, which liability was capable of being continued under Section 272. However, at the time of dissolution, it had not yet been invited to exercise its discretion under Section 280 so as to impose an order requiring the appellants specifically personally to compensate the respondents. It was only asked to do so subsequently, and the first and only occasion on which the court exercised its discretion to make such an order was in May 2016, when the Court of Appeal delivered its judgment. You heard my submission that until the discretion is exercised, no liability exists, nothing is capable of being continued. The Court of Appeal were therefore wrong to conclude that the appellants were under a liability at the time of dissolution. The reason why we say the Court of Appeal wrongly assumed that the directors were under a liability within the meaning of Section 272 was because they, and this is important, in our submission, wrongly equated mere oppression with liability. The Court of Appeal rightly accepted the basic principle that for the purposes of a claim under Section 280, the oppression or unfairness resulting from the director's conduct must exist when the action is filed. That's manifest from paragraph 15, record 32, page 870. Having identified the basic principle, the Court of Appeal immediately went on, section 16, to cite section 272, concluding that its effect was clear. The removal, final sentence, the removal of a company from the register of companies does not extinguish the liability of the company or its directors. At paragraph 17, the Court of Appeal then identified the oppressive acts complained of, and having done so, it said, as noted, liability for this oppressive behaviour is not extinguished by the removal from the register, and that, of course, was a reference back to section 272, and was the sole basis on which the appeal was allowed. Nowhere in these short paragraphs did the Court of Appeal pause to identify the liability which, in their opinion, section 272 continued. Had they done so, they would have appreciated that there was none. There was no liability within the meaning of section 272, because at the time the company was struck off, no court had exercised its judicial discretion under section 280 to impose such a liability. And until that happened, there was no liability capable of being continued. Instead, the Court of Appeal assumed that mere oppression amounts to liability. Section 280, because of its discretionary nature, anticipates that there may be oppression, but no liability. Absent a pre-existing liability, section 272 simply does not apply. So it was this assuming that oppression equals liability where the court fell into error. And then very quickly, if I may, just the final 6 propositions. which summarises the appellant's case. The Court of Appeal's decision was founded on Section 272. The effect of Section 272 is to continue a liability, not to create one. It applies only to a liability of a director in existence at the time when the company is removed from the register. 3, when on the 25th of July 2008, Alicat Designs Limited was removed from the register, the appellants were not under a liability because no court had exercised its discretion under 280 and no court had come to the conclusion that the fit remedy was a compensation under J. 4, it follows that Section 272 did not apply when Alicat Designs Limited was removed from the register. There was no liability in existence which continued. 5, this remained the position when the Section 280 proceedings were commenced on the 21st of April 2009. And 6 and final, the Court of Appeal were accordingly in error in placing reliance on Section 272. The section did not, and in our humble submission, does not apply. And accordingly, we submit with respect that the decision of the Court of Appeal was wrong, and that your Lordships and your Ladyship should advise Her Majesty that the appeal should not be allowed. Unless I can assist you further, those are my submissions. And
thank you very much
for going over time.
Ms. Gops, do you wish to add anything? Thank you. Mr. Parker.
Large, my lords. My learned friend didn't spend much time with the facts, the findings of fact made by the trial judge. As he concluded his presentation, he says that the Court of Appeal assumed that there was liability on the part of the appellants that was continued by Section 272. Whereas the true state of affairs is that Her Ladyship, the trial judge, made specific findings of liability. She found them liable for the conduct, for the specific conduct set out comprehensively in her ruling. But we will begin at the beginning. The appellants, before the trial judge, filed a summons to strike, whereupon the trial judge, had to make a determination whether or not there was a reasonable cause of action on the pleadings as against the appellants. Considering the evidence, considering the originating summons, Her Ladyship found that based on the pleadings, there was a reasonable cause of action as against them for the violations pleaded, for the relief sought, basically compensatory relief under Section 280. My learned friend, in his submission, seeks to artificially circumscribe the term liability. He has advocated a definition of the term liability, which we are hearing for the first time today. Nevertheless, we tendered the definition of liability as proposed by Jowett's Dictionary of English Law, which defines liability as follows: the condition of being answerable in law or actually or potentially. This is at page 1432 of the record, tab 37 of volume 2 of the authorities.
Sorry, page again?
1432.
14.
Tab 37 of the physical volume 2 of the authorities. And reading again, the condition of being answerable in law or actually or potentially subject to a civil obligation, either generally as including every kind of obligation or in a more special sense to denote inchoate, future, unascertained or imperfect obligations, as opposed to debts, the essence of which that they are ascertained and certain. Thus, when a person becomes surety for another, he makes himself liable, though it is unascertained in what obligation or debt the liability may ultimately result. The term can also mean, for being the condition of being actually or potentially subject to a criminal sanction. The obligation itself. I'll stop there.
I mean, that's obviously very wide.
Yes, it indeed.
Suits your submission.
Yes.
But how do you reconcile that with Section 255, which specifically in terms adopts a very wide definition of liabilities, including potential contingent,
Yes.
whereas our Section 272 doesn't? I mean, surely isn't that an indication that the draftsman was not using it in that wide sense?
It does not mean that the draftsman indicated the interpretation advocated for by my learned friend. It means that they adopted less expansive language, but the definition of the term liability that my learned friend advocates before the court is not necessarily that which Parliament intended. What Parliament intended when my learned friend talks about the mischief intended or the deterrent effect is to ensure that when a company is removed from the Register of Records for reasons, as my learned friend accepted in his case, are typically within the purview of the directors themselves, that they do not escape liability for that conduct. So when
I
we
think
come
Section 255 is defining debts. It is giving an extended meaning to debts rather than liabilities.
Yeah.
And as you've shown us with Jarrett's dictionary, the word liability can mean more than a debt.
Yes. And it is, what we say reflects the natural and ordinary meaning of the term liability, actually or potentially. The nature of the oppression remedy is that relief flows from conduct. The liability is you attract liability by the way you conduct yourself. It flows from the actions of the directors, the exercise of their powers, the affairs of the company, how they are conducted. So the question of when they became liable is not a question of the courts making a finding or declaring it to be such. The liability flowed from their conduct. And as her ladyship found, the conduct as alleged had been committed, the actions had been taken, the effect had been suffered by the respondent long before the company was removed from the Register of Companies. So it was important to highlight as we begin, when we come to consider what the Court of Appeal did, it is not correct to suggest that the Court of Appeal assumed anything. There was a finding of fact made by the trial judge. A, that they committed the acts complained of. B, that it had the effect on the respondent complained of. And C, that they were liable as a result. With those ingredients having been established by the trial judge, we submit the application of Section 272 is axiomatic. It flows. That there is nothing unique, more importantly, about liability under Section 280.
Well, it might be said that if a director acts in breach of fiduciary duty, or under this legislation in breach of Section 81, then they, as a consequence, they incur a liability, at least in a broad sense. And that, as Section 81 tells us, the liability is capable of being, the duty is capable of being enforced in the same way as other fiduciary obligations. The problem with Section 280 is that it's providing a remedy for oppressive conduct, and the nature of a remedy is very open-ended. It's a matter for the court to choose what it thinks is the most suitable remedy, and in a case like the present, it has a choice. It could choose a remedy directed against the directors, which might be in favour of a creditor or might be in favour of a company, or it could choose a different form of remedy altogether by, for example, appointing, by putting the company into winding up, conceivably by appointing a receiver. And so it might be said, until the court has actually considered the matter and decided what's the most appropriate sort of remedy to grant, there can't be there is no liability, even in a wide sense, that can be said to already exist.
What we would say to that is that the liability of the directors that triggers or empowers the court to have regard to the broad relief available is the conduct, as we say. And we say that to suggest that they are not liable because the court has broad powers, remedial powers, is to derogate from the fact that Parliament intended that the directors be answerable for their conduct, notwithstanding the removal. And furthermore, that when you come to consider directors' liability, you are to consider it as though the company remained.
So is it enough that the director's conduct has given rise to the possibility that an order might be made against them under Section 280?
Yes, my Lord, because that is what Section 272 is aimed at. My learned friend talked about certainty on the part of directors, and one of the things we traverse in our written case is the fact that a director who doesn't conduct himself or herself in breach of their fiduciary duties or their statutory duties under the Act, who doesn't contravene the provisions of Section 280 and oppress the interests of a shareholder, creditor, or a debenture holder, they would not necessarily be in a risk in under any apprehension of an application under Section 280. The reality is that if you conduct yourself in accordance with the clearly stipulated statutory guidance and the common law rules, then you have, as they say, nothing to worry about. But to say that because they could potentially be liable, we have to construe Section 272 in a narrow fashion to give them some certainty, I think prejudices the complainant or the plaintiff who is supposed to be empowered by Section 272, and it deletes, or not deletes, it derogates from the deterrent effect of Section 272 when you, in order to accommodate the directors, circumscribe, artificially we say, the definition of the term liability in the circumstances. So, and
Now, I wonder if that might be a suitable point for us to adjourn.
yes, well,
Very well then.